Hello, Miss Francine. Here we are. This is Brent. Brent Allen Winters, commonlawyer.com, www.commonlawyer.com, coming at you from the remote hinterlands of the Wabash River Valley, where the hogs, the frogs, and the dogs keep up a racket all night long. Well, a significant slice of that is the laws of nature, and our Constitution of the United States it's not the Bible. No, no, no. It's not on the level of the Bible. No, no, not at all. It is God having revealed himself through the centuries, how things work, and men do figure that stuff out. After a while, I know we're hard-headed, but he slams us around and slaps us around until we figure it out, and then we move in the right direction. Then we discover, if we go far enough, that the Bible undergirds all of this, all of the things that we observe in life, undergirds it and gives more precise detail. Law written, law unwritten, nature. What we see, what we observe, how things are, and they ain't going to change. And then law written, the Bible. Let's talk about our Constitution, or as one of my professors used to say, the Constitution. Constitution of the United States. You know, back in my neck of the woods in the Wabash Valley, people traditionally, they've added a lot of R's to the word. You know, if you go to New York City, you'll find out they put R's on the ends of words. They don't say law, they say lore. Lore. Miss Francine and I know a fella. We used to listen to him and go to his weekly presentations. He was from right above New York City in the Hudson Valley, and he'd talk about the common law. I'm not saying it the way he said it. I just can't do that. These New Yorkers got their own way of doing it. Well, they put the R's on the ends of the word, but in the Mississippi and the Wabash and the Ohio Valley, I've watched people put their R's in the words. They didn't say where I come from. Abe Lincoln's parents lived not close to where I come from. They had traveled south. They were in southern Indiana. You know, Lincoln was born in Kentucky, and then they migrated across the river into southern Indiana, and then into Illinois. But people in that part of the world, when I was growing up, they didn't call him Abraham Lincoln. They called him Abraham Lincoln. Lincoln. Everything was corn with them. Still is with some people around there. Depends on who you talk to, C-O-R-N. And then I got to reading, and I discovered that wasn't, I thought maybe it was some modern mispronunciation, and I discovered that Abe's family talked that way. And his cousin, Denny Hanks, by the way, Tom Hanks claimed to be related to Abe's cousin, Denny. I don't know if that's true, but Denny Hanks, he grew up with Abe, and he was a cousin. And he called that side of the family the Lincoln family, and spelled it that way when he wrote letters. Lincoln. Well, this is the Constitution, and we're trying to eliminate the confusion about the Constitution of the United States. Miss Francine is being very persnickety about telling me where we're starting here. Don't say it, I got it right here. Question 253. Here's a question. Arthur J. Stansbury's Catechism on the Constitution of the United States. Catechism, that means a series of questions with answers that the student learns. There are 333. Question 253, we've done them all up till then, says, suppose his cause has to do with a law of the United States and not a state law. Answer. Well, here's the question. That's questions based on the previous, so I have to read the previous question. Can a litigant, a man that wants to go to court, can he take his case from the state court to the court of the United States? Well, the answer depends upon what it's about. Again, to stress this point, the state courts, for our purposes here, the fundamentals, the state courts of every state have unlimited jurisdiction. There's not any case that they don't have jurisdiction to hear. Cases concerning the Constitution of the United States, they have jurisdiction. Cases concerning state law, they have jurisdiction, and they have authority to take that jurisdiction, indeed, a duty to take it. But the federal courts, very limited scope of jurisdiction, very small by comparison. Limited according to our Constitution. The federal courts are limited to matters and cases arising under the Constitution of the United States. Now, when you learn that stuff, they say, well, cases and laws and treaties arising under the Constitution of the United States. I don't know why people say that. Law professors teach it that way. Well, laws of the United States and treaties of the United States all arise under the Constitution. Why do we say that? Just make it simple and say any dispute in courts that arises under some provision of the Constitution of the United States, the federal courts can take jurisdiction over, indeed have a duty to take jurisdiction. It makes us angry sometimes, and rightly so, that the courts will not hear cases that arise under the Constitution of the United States. For example, election fraud. We had cases of election fraud all over the United States, massive, gross trespasses of laws of the United States, and those laws arise with the Constitution of the United States and the federal courts all over the country. Oh, we can't hear that. Oh, you filed too soon. It's not ready to be heard. Okay, we'll come back. Oh, you came back, but you filed too late. It's too late now. You can't file now. What were they doing? They were weaving and dodging. Dodging. They weren't even punting, saying go take it to another court. Like they were backed up against the goal line, didn't know what to do. They got the ball and punted, tried to throw it back, to kick it to the other end of the field. Do you remember Jim Thorpe? James Thorpe. He was a red man, an Indian. He was from an obscure tribe of the Fox dialect, like the Kickapoo, that lived in Oklahoma. He grew up, as you can imagine, out in the middle of nowhere. Born back in the 1880s. And somehow he got an opportunity to go to the Indian school in Pennsylvania called Carlisle, that the federal government had established for Indian boys. And there happened to be a athletic coach there who was a white boy, and his name was Pop Warner. Pop Warner. Pop Warner is not the inventor of football, but if it hadn't been for Pop Warner, there wouldn't be any football. So he was Mr. Football in America at that time. Jim Thorpe, James, was at school there. He didn't know anything about sports. I mean, the only sports he ever participated in was trying to run and jump across the creek down there in south central Oklahoma where he lived, or trying to outrun a bear. Maybe he did that. Or try to chase down a deer with a rifle. He did that. But Jim Thorpe wasn't just good. It is unbelievable what that man did without any training. None. He walked by the track there at Carlisle one time, and he didn't know what they were doing. They had a high jump bar up, and the boys were trying to jump over it. And they had it set at 5'9". Now, you stop to consider how high that is. He wasn't on the team. He was in his street clothes. And he asked if he could try. He was kind of hesitant. He asked if he could try. He just had his regular street shoes on, maybe his boots, I don't know. And And the testimony of the boys that watched him jump, he just took a run at the bar and jumped, and they said he cleared it by at least 4 inches. Well, the coach said, wait a minute, what's your name? No, you got it. We want you to be on the team here. Can you be on the team? Can you be on what team? He didn't even know what it was. I mean, he grew up as a tribesman. He didn't grow up with the white boys. He didn't know anything about the white man's world. He was on another planet at that time. Well, Pop Warner found out about it. I'm just going to tell you one story. The King of Sweden told Jim Thorpe personally in the 1912 Olympics, he said, you, sir, are the greatest athlete in the world. And he was. And he would be today. He ended up jumping 6'6", not to mention every other event in track and field, excelled at all of them. Well, Warner got him on the football team. And the big game was played in Soldiers Field in Chicago, Illinois, against Harvard University, the #1, and all these Indian boys in Harvard. True story. Jim Thorpe played every position. If they needed somebody in a position, he also was the field goal kicker and the punter. Every specialty team, every position, defense, offense, he played it all. And as long as he was on the team, he carried the ball. He played right tackle, left tackle, and offense and defense. And he was a running back. And they won every game but one the first year he was there. Again, no training. Didn't even know what he was doing. Didn't even know the rules, probably. He just know, give me the football and I'll try to run across that line down there. And he did. They won every game by wide margins. And then he injured his foot. They didn't think he's going to make that Harvard game. And they said, hey, boy, as long as Jimmy boy is on the team, we can go up Harvard. And they thought they were really hot, as you can imagine. I mean, Soldiers Field. People still play ball at Soldiers Field. It's that field, if it's old, famous. In Chicago, it's got on one end, it's got this stone wall with ivy growing on it. And if you're playing ball there and you're running to catch the ball or something, you run into that wall, it's all over but the crying. I mean, there's no padding, That's one of the things about Soldiers Field. They've never changed because, well, people just got used to it, and they think the boys play tougher ball if they have that there. It keeps them on their toes, I guess. Jim really busted up his ankle. They didn't think he was going to play. Pop Warner knew, how are we going to win this game? We will lose this game without Jim. If we have Jim, we won't just win it. We'll teach those white boys who's boss. That's really what they wanted to do. See, they saw Jim Thorpe. He was bringing national attention to what the red boys could do. They could compete with the white boys, not only compete with them, they could whoop them. Of course, they'd lost all the engine wars, see, so they were feeling kind of down and out. See, if you're a defeated person in war, a defeated country, it changes your whole attitude. Did you know, our country has never been defeated in war. Never. Never. You say, what about Vietnam? Oh, we never lost a battle in Vietnam. We just left. We won every major battle that we fought there. Did you know that? Oh, yeah, every one. How about Korea? Yeah, we won all those too. And then we decided to leave. I don't know if that was smart, but that's what we did. Americans have not had the experience of losing wars. And just tell you what I know reading history, when you lose a war, it's hard to mount to anything because it's an attitude thing. Why is Germany in the awful position they're in today? Awful. Their manhood's taken away. They lost the war. Well, they think their manhood is taken away. I've had people tell me they go to Germany and they say, manhood is gone there. They're a defeated nation. You can cite all the reasons. Same thing with the American South. I used to read, that fella had that French name. He wrote more about the history of that war between the northern and the southern tiers of the states. Well, you know who I'm talking about. Look him up. He's from down in Louisiana. He's gone now. He wrote volumes. And he wrote it all. This is the funny thing about that guy. Shelby. His first name was Shelby. It was a French name in the end, like Lafoot, but I don't know that was it. Shelby. Anyway, you look him up. Type in Shelby, historian of the Civil War. Maybe his last name was Shelby. Well, at any rate, just type in Shelby and he'll come up. He's the most famous. He wrote all of those volumes with an ink quill pen. Everything. Didn't type, not a typewriter, not a computer, no. Not a regular fountain pen or a pencil. No, he used ink and he wrote it like that. He was to be a good historian, you want people to believe what happened in the past. If you're a good writer and can keep their attention, your point of view will prevail as history, and that's what he was trying to do for the South. But he makes this point, and I think this is why he wrote as much as he did. He thought he could write good enough that people would want to read his writings, and it was changed the perception that the world had of the South as a defeated country. Because the North didn't just defeat them, they wiped them out. And they were stupid to think that wouldn't happen. They were stupid to get involved. They were stupid to taunt the North, and I'm in good company when I say that. Good Southern company, by the way, a lot of Southern company, more than there were that wanted the war, including my own ancestors who were from the South and fought in the Union Army. They were stupid. The Bible says, Jesus Christ says, when a man goes to wage war, he sits down and calculates whether or not he can win. He pushes the pencil, men, material, strategy, willpower. What have I got? They didn't do that. They were stupid. Japan didn't do that. They were stupid. And Germany didn't do that. And they were stupid. Just simply did not say how much diesel fuel do we have by the gallon compared to the Americans. Japan didn't do that either. They had none. It wasn't going to happen. Well, that's the way it was with the South. It wasn't going to happen. And in all three of those cases, they all said the same thing and promoted it by propaganda among their people. Well, we may not have industrial might, materials, butter, and guns, but we have bravery, we have spirit, and we are right. Jesus Christ said, forget it. The way God has structured the world, you don't do that, you'll lose. If you want to lose, okay. Do not pull a gun on a man that's got the drop on you. That's the lesson. But God said don't do that. No, bide your time. Wait till you have the advantage. That's what you do. Oh, you can win, but don't be stupid. He who fights and runs away will live to fight another day, but he who is in battle slain shall never rise to fight again. No, don't just fight on the other man's turf. No, you stop and wait. No. I'll kill you later. I'll fight later. I'll do whatever I got to do. No, you got me surrounded now. It ain't fair. It ain't a fair fight right now. George Washington refused to face off with the British Army for 7 years. It's a long time, friends. A long time. He refused to face off with them. No, they called him the fox. He was elusive because they wanted to face off with him, but they couldn't corner him and they couldn't find him. A lot of times. What was he thinking? As a matter of fact, Congress almost fired him because what the world wants is, what's the matter? Aren't you brave? Don't you? No, I'm not stupid. You can talk that bravery line all you want. That's not what wins wars. Oh, it happens, but that's not what wins wars. Men have material enough just reading about the Thompson machine gun. First brought into play in war on Guadalcanal, 1942. The Thompson. The Japs made fun of the Thompson. That's stupid. That thing only has a muzzle velocity of 800 feet per second. Those rounds are too big. No, we're into precision. We fire one shot. Germans said the same thing. Oh, we're into precision. We fire one shot. Well, you Americans just want to spray bullets. Well, made the Americans kind of nervous, but they armed the Marine Corps. Every private soldier was carrying a Thompson. Fires 600 rounds per minute. Now calculate that. That'd be 300 rounds every 30 seconds. Am I right? Yeah. 300 rounds every 30 seconds. That'd be 100 rounds every 10 seconds. That'd be 10 rounds a second, right? Yeah, right. If I'm wrong, somebody will tell me. I think the Tommy gun fires 10 rounds a second, 45 caliber, slow rounds, 800 feet per second. The Japs were very brave. They bonsai charged with bayonets. The Marines didn't know what would happen. Nobody ever used Thompson in battle. It had a bad reputation as a gangster movie kind of fantasy weapon. They started firing those Thompsons. And Japs were bewildered. They didn't know what to do. Whoa, what happened? Bodies strewn everywhere. They thought they were going to just drive them back and kill them all because they had spirit, courage, and discipline. Jesus Christ clearly says otherwise. My brother went to the Naval War College. I said, "What did you learn?" He came back. He said, "Well, two things. Number one, you can't pay a man a big salary to die for his country. He won't do it. You can't pay a man a big salary to die for his country." That's what happened at Waco. Those FBI agents finally thought they'd storm that compound. And all of a sudden, real bullets were flying through the walls and the windows, and men were dying and being maimed. And they crawled down off that roof and they were crying like babies. Wait, we didn't sign up for this. You're getting $150,000 a year. Get up there. No way. Why? Because they were fighting for money. They were doing what they did because they thought it was easy, and they thought that it was fun to be a Rambo and all that stuff. But you can pay a man $10 a day and tell him he's fighting for his country and his wife and his children, and he'll die for it. He'll do it. The realities of war. Let's understand the fundamentals here. Getting all hyped up and worked up isn't what wins wars. People do it. Oh, they get you hyped up and worked up. That's not what wins wars. You got to be hyped up and worked up to be methodical and say no. We got to overwhelm the enemy and crush them. And if don't have that mindset, you're going to lose. We're going to bring democracy to Islamic countries. Right. How stupid can people be? Religion is the foundation of all government. You're going to take Islam and make freedom out of it? That ain't going to happen. What we do? Well, we ended up just walking away like we did in Vietnam, like we did in Korea, because we weren't fighting for dirt. Two things you got to do in war. You fight for dirt and you take it. And you overwhelm the enemy. That's what Jesus Christ says. It's all about land and it's all about winning. And the way you do it is with resources. That's the command of God. Oh, to know the truth. Just get down. Wait, is there any authority here that tells us the final truth on it? Yes, there is. This book we call the Bible is the final court of last resort. It is pure truth, and all of it is for all of life. When I was back in the early 80s, I was a lot younger then, late 70s, well, into the early 80s. I really began to get interested in the Bible. I learned it as a kid growing up, the stories, but at that point, I really got interested, and I went whole hog. I said, I got to know this book. And the fight at that time was over the question of inerrancy. That fight was raging in America and all over the world. Inerrancy of the Bible. Inerrancy, that's the doctrine of Jesus Christ that says the Bible has no errors of fact. It doesn't communicate any errors of fact. And Jesus Christ makes that clear. A communist by the name of Joel His name came to me. I tried to say this the other day and I couldn't think of his name. A communist by the name of Joel Cadbury. Joel Cadbury, professor at Harvard University, a communist and a Quaker. And through the centuries, Quakerism and communism have gone together. There have been a lot of communist Quakers because they have a faulty view of the fundamental nature of man. Well, this fellow's name, Henry Joel Cadbury, he was a philosopher and a theologian from Harvard University. Back about, time flies, about 100 years ago. I call that modern times. Henry Joel Cadbury, communist, Quaker, what confusion. But he didn't believe the Bible was inerrant. But he did say this. He was an honest guy on this point. He said this: if you're going to follow Jesus Christ, you're going to follow his teachings, then to be consistent, you must accept that the Bible does not communicate any errors of fact. I mean, if Jesus Christ said that God is my Father, well, God is his Father. That's a question of fact. If Jesus Christ said that I cannot communicate with the dead, then I can't, because that's a question of fact. And the Bible communicates no errors. If Jesus Christ says that you, the Pharisees, serve your father the devil and do the will of your father the devil, that's a fact. Now, whatever he means by that, we can explore more of what that means, but whatever he said is just a fact. Has no errors of fact. Henry Joel Cadbury of Harvard was honest on this point. The Bible, the record of what Jesus Christ said, tells us clearly that he believed and promoted the idea that the Bible has no errors of fact. Of course, the left wants to ignore Henry Joel Cadbury, but he was one of theirs. I'm not quoting some Christian theologian. But why does Henry Joel Cadbury have to say it? It's so blatantly, no, blatantly, blunt and clear. Blatantly and bluntly. Now, if I turn that around, it'd be bluntly and blatantly. So, yeah, I guess that'd be it. But at any rate, no errors of fact. When I was a young man, that was the raging. The Southern Baptist Convention split over that question. I'm not a Baptist. I always say that. I don't want to be a Baptist. I got Baptist friends. I'm not a Baptist. I've never been a Baptist. It's not like I'm rejecting something I taught when I was young. I've never been a Baptist, ever. Don't want to be one. Whew. But at any rate, they split over it. A lot of other denominations split over it. You know, that's what continually happens. Truth is never preserved unless churches fight and split. And it never is. During the war between the northern and the southern tiers of the state, the Methodist Church split into the Northern Methodist and the Southern Methodist. My grandma Mackenzie was a Southern Methodist. That's right. And also, she at times was a Southern Presbyterian. That's kind of funny, but yeah, she did both of them. Then she went, I think it was because the Southern Presbyterian Church, it split up and went away. And so she started going to the Southern Methodist Church. But there's Southern Baptist, see, Northern Baptist, there's still those two denominations. Southern Baptist got a lot bigger than the Northern Baptist denomination. The Southern Baptists are all over the world. Southern Presbyterians, Northern Presbyterians, that's where the split in our country between what the southern states were saying they were following when it came to government in the northern states, it was a religious split. Do you see that? And the proof of that is all these major denominations split into North and South. It's impossible to have government without a lawgiver, a God. And our response to our lawgiver, that's the definition of religion. Whoever you take to be your final arbiter of right and wrong, your response to that, whoever you take that to be or whatever you take that to be, is religion. And everybody's got it. Well, the proof of that again is in what happened, the split of the denominations. But Split in the split then later came over inerrancy. That was a battle that was fought from the early 1900s up through the 1980s, and into the 90s a little. And that was a controversy that was really raging when I was young and really interested in the Bible. Convention was held in Chicago, Illinois, and the men that wanted to reinforce the authority of the Bible and the inerrancy drew up a statement called the Chicago Statement on Biblical Inerrancy. And they all signed it. And well-known men. You can find it on the internet. They called it the Chicago Statement because that was the central location for all of them. They decided they would meet. All of them. As of about a month ago, the last one passed away. That happened while I was paying close attention to the Chicago Statement. John MacArthur was the last one that signed it, and he passed away just a few weeks ago. It's a good statement. You can look it up. What does biblical inerrancy mean? As I said, just boil it down. You can read the statement, but the Bible communicates no errors of fact. If the Bible says that a false prophet prophesied falsely, it's a fact statement. He did. And if the Bible records what he says in his false prophecy, well, that's a fact. That's what he said. Well, jurisdiction in the courts. I think we got off track a little. Somehow I thought it was important to mention that. Limited jurisdiction of the federal courts and the unlimited jurisdiction of the state courts. But if somebody files a case in a state court that arises under the Constitution of the United States, that's okay. But if one of the parties says, I'm taking this to federal court because it's a constitutional question, this matter arises under the Constitution of the United States, and he removes it to federal court, that's okay. That's where jurisdiction will be fought out. It may be thrown back to the state court, but it may not. I've had that happen. Lots. Well, quite a few times. Not thousands, but some. Well, what are the, suppose his call, here we go. Question 254. What are the courts of the United States? And we're going to repeat what we've said the last 3 weeks, maybe in a different way. And that's what he's doing. He asked questions that come back to the same principle, but he comes at it from different directions. That's good. What are these courts of the United States? As distinguished from the state courts under our Constitution of the United States, 2 different jurisdictions, 2 different sovereignties. The courts of the United States consist of one Supreme Court of the United States. One Supreme Court of the United States. The court of last resort among the federal courts. The court of last resort. There's no place you can appeal beyond that court. Down here on land, you can always appeal to the sovereign court of heaven and earth. As our Declaration of 76 says, the supreme judge of what? All the world. All the world. What's the world? Vergeld, the Vergeld, the Wettereld, this age of man. All the world is God on high. I think I'd mentioned to you at common law, if you've exhausted all your remedies and all the courts of last resort, you finally got there, then our common law says you have the option of appealing to heaven. Yeah. Even in this country, that didn't go away until about the 1840s. Or in England, it didn't go away. They've never passed a statute to do away with it, so it persisted. It just fell out of vogue. I think the last time it was invoked in the United States was in North Carolina back in the 1840s. It's called trial by battle. Instead of battle by trial before the jury, you have exhausted all that. You've exhausted all your remedies in the appellate courts, the Supreme Court of the United States, if you're in the federal courts. Then you could make application trial by battle. A federal judge named Pickering. When Tom Jefferson was president, a federal judge named Pickering, Tom Jefferson moved for his impeachment. Asked the Senate, the Congress, the House of Representatives, to impeach him. That's like a grand jury indictment. And then, once he's impeached, he's held for trial before the U.S. Senate. And Judge Pickering said, I appeal to heaven, and challenged Tom Jefferson to a duel. Trial by battle, according to very stringent rules. This isn't haphazard Hatfield McCoys ambushing each other. No, it's all up front, it's public. Andy Jackson did that more times than you could count. Andy Jackson carried more pistol balls in his body than, well, they said when he walked, he rattled like a bag of marbles. Why, he was appealing to heaven, trial by battle, and all the remedies of the courts. It's against the law now in every state, as far as I know. The state treasurer of Illinois challenged Abe Lincoln, who was a lawyer at that time, to trial by battle. It was against the law in Illinois. So they went to an island on the Mississippi River between Missouri and Illinois, and the island, well, the jurisdiction wasn't established, so they went there and they chose the one who's challenged gets to choose the weapons, and Lincoln had long arms. Being the galoot he was, he chose broadswords. Probably a wise choice. Obviously, he didn't lose. Well, that's another story. But the Supreme Court of the United States is the last court of resort within the court system of the United States at the federal level, in the federal government. And the Supreme Court of the United States, because it is a federal court, has a narrow scope of jurisdiction. Narrow, very narrow. Just cases that arise, a question that arises under the Constitution of the United States. You see, that government, D.C., doesn't have any jurisdiction, Congress, the president, to do anything that the Constitution of the United States does not give them authority to do explicitly. No, not implicitly, explicitly. If it isn't clearly stated in this a document we call our Constitution, then the president, the Congress, well, let me give you an example. Sometimes our Constitution says it in the negative. It'll say, First Amendment says, Congress shall pass no law respecting what? An establishment of religion. That's pretty clear, isn't it? Congress doesn't have authority to say jack squat concerning this religious group or that, respecting any particular establishment, any particular denomination, any particular organization of religion. Does not have any authority to do that. Well, that's a pretty narrow scope of jurisdiction. Do the states have that authority? Can the state of Kansas say, the legislature passed a law says, we hereby pass this law saying that the Lutheran Church is the state religion, or the state religion of this state of Kansas? Well, under the Constitution, when it was drafted, and just taking it that way, yes, and states have always had that authority. Yes. All the 13 original states had some form of state mandated religion in their state when our Constitution was ratified, and it was ratified with that understanding that states control that, not the general government from Washington, D.C. That's why the First Amendment is there. Let me give you another example. No, but do we do that? No, through the doctrine called incorporation, we say we've stopped that. I'm not sure that's constitutional, although it's been going on since World War II. Let me give you another example. Do the states, the individual states, have the authority under our United States Constitution and the state constitution, the divisions of jurisdiction between the sovereign state governments and the sovereign general government? Do the states have authority to pass a law, the legislatures to pass a law and say, abortion is legal in this state? Answer, yeah, always have had. And that's why the Supreme Court overturned Roe v. Wade. They said, this is none of our business. We don't even have Roe v. Wade was a violation of the jurisdiction that the Constitution of the United States establishes for the general government in Washington, D.C. Our jurisdiction has nothing to do with murder. That's what abortion is. Has nothing to do with religion. We don't have jurisdiction to even talk about it. So they overturned Roe v. Wade. They threw it back to the states to decide individually. Here's another one. What about gun control? Well, until 2008, we could say clearly, that was the Heller decision, we could say clearly, if any state legislature wanted to make an absolute ban on firearms, they were saying we have the authority to do that. Now, they never did have that authority. That's what a lot of people were saying. Why don't they have that authority to ban all firearms? Remember, the Heller decision was followed up by Chicago versus McDonald versus Chicago, which applied the Second Amendment rights to the states, and the gunners won both of those cases, so that's good. But the Supreme Court is not there to declare what the law is and say, well, we're telling here's what that's not what they're doing. We're a common law country. What do? They don't make law. They find it and declare, well, here's what the law has always been, and here's what it is, and we're telling you what it is. We're just reaffirming what the law is. The brooding omnipresence of the law. We found it. This case came up, so we need to look, and they look, and here it is. Okay, yeah, clearly this is the law, and then they declare it in their opinions. That's what all the courts are supposed to do in our common law tradition. The law is always there. They don't make law. The legislature is not to make law. Legislation in our common law tradition is not they make law. No, they reinforce the law and the truth that is already there. The brooding omnipresence of the law, as Justice Joseph Story put it. Swift versus Tyson. Well, you say Swift versus Tyson is overturned. Erie Railroad overturned Swift versus Tyson. No, it didn't. The left has always wanted it to. It never said that. It made the point, oh, well, no sense getting into that. But just listen and maybe things will gel. I'm trying to just give you the little piece of the big picture constantly. And you'll come to your own conclusions. That's the point here. I'm not here just to tell you what to do. Miss Francine, I know you're ready with a song whenever I slam shut my tater trap on this matter. Let me keep going here. Yes, we have our Supreme Court, we're going to say this again, our Supreme Court of the United States has established one court. Yes, one. Our Supreme Court, no. Oh boy, I think I'm like the snake eating its tail. I'm starting to run circles. Let me say that again. Our Constitution of the United States establishes just one court. Our Constitution establishes just one court, which means that the militiamen of the states have established just one court using that Constitution. That's the document that they used to establish that one court. What is that one court? It is the Supreme Court of the United States. You see, that document establishes three branches of government: the Presidency of the United States, the Supreme Court of the United States, and the Congress of the United States. The Presidency is the executive branch. The Congress is the legislative branch of that government, that general government in Washington, D.C. And the Supreme Court is that judicial branch. That's it. Well, where do we get all these other federal courts? Well, the Constitution of the United States, in establishing Congress, gives Congress jurisdiction to establish other federal courts. And they've done that. They didn't have to, but they have done it. People often ask, why is it that when our country started, before Congress had had time to establish all these other courts, when our country started, the Supreme Court of the United States impaneled juries and held trials. Why is that? Because they were the only court, and it was understood if they wanted to hear a case that arose under the Constitution, they could hear that case. They could try it, and they still have that authority, by the way. For example, did you know that any questions involving ambassadors from other countries go straight to the Supreme Court of the United States? Any questions involving treaties with other countries go first and right to the Supreme Court of the United States. And if the Supreme Court of the United States wants to impanel a jury and try the case in a full-blown trial, they have jurisdiction to do that. I wish they would. They used to. But they're independent. You see, they're constant independent of the other two branches of government. The other two branches of government can't tell them how to run their business. Our common law forbids that. And nothing in our Constitution tells the Supreme Court of the United States how to do their duty. It doesn't say whether it has to be 9 judges, 50 judges, 5 judges. When our country started, there were 3 judges on the panel of the U.S. Supreme Court. If they want to serve as a 3-man jury and try a case, or just decide the case themselves on the evidence that's come up from the other courts, they can do that. They can do whatever, they can do it any way they want. But what they have done, because the only thing they knew, we're in a common law country, our Constitution doesn't tell them how to do it, they follow the principles of our common law that are not written. Do we stop to consider how strong those principles are in our common law culture? No place in the Constitution does it say, well, the law is whatever 5 of 9 Supreme Court justices say. If 5 of them agree, that's it. It doesn't say that in the Constitution anywhere. Why do we follow that principle? Oh, because they act like that's what they want to do, but they haven't said. They haven't said, the Supreme Court hasn't said, as far as I know, if 5 of us decide this, then that's it. That's the verdict. I don't think that's ever been said. Well, what do they do then? They deliver opinions. Opinions? These aren't declarations? No, they're opinions. Pretty weak word, isn't it? They deliver, watch this one, findings. What are the findings of the court? Well, they say they're the court. They're supposed to go find out what the law is because the law never changes. They just need to look and find it and come up to their conclusions and write it down on paper. And they each have a responsibility, if they want to take it up, to either write their own opinion, all 9 of them, or some of them join somebody else who writes, or they can join the opinion, then write separately to make another point. They do all those things. What are they? Listen, friends, their decisions and their opinions apply to what? The case then before the court. That's all. And by the strongest of common law traditions apply to the courts underneath that hierarchy of federal courts. Doesn't say that in the Constitution anywhere either, but we sure do it that way. And I mean, it is a strong, powerful tradition. Our common law country has drank the potion of our common law. It's a good potion. And it's just the way we do things. We think in those terms. That's what makes things work, friends, because our Constitution of the United States does not flesh those details out. It doesn't flesh out any details about anything it says. It doesn't explain anything, nothing. It just states it. Boom, 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 boom. Fact, fact, fact. This is our common law tradition. You know, the Bible does that too. Not everywhere. Sometimes God explains things, but in other places he just says, like Paul the Apostle says to the Corinthians, I have delivered unto you that which I have first received. Boom, 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 boom. What he received? The facts about the birth, the virgin birth, the life, the burial, the resurrection, the ascension of Jesus Christ, fact, 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 based on what? Evidence, 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 and the Bible is the evidence recorded. Well, our common law is about evidence too. Experience. Our common law, Holmes got this right, is experience. Well, this is what happened, this is what works, and we're going to keep doing it this way. We're tied to the wisdom of the past. The law of the city wants to obliterate the memory of the past